Ann Rice.
Good afternoon, Madam Chair, members of the committee. I'm Ann Rice. I'm the Deputy Attorney General, and I'm here in opposition to this bill as written. The Glick decision that Representative Watrous mentioned, after that came out, and after House Bill 145 was being heard in the House and Senate, we sent out a letter from our office notifying all police departments and all prosecutors of the Glick decision to make sure that those sorts of circumstances did not happen. Now, I don't know timing-wise if our notice had gone out at that point, but certainly, if that's the issue, I'm certainly willing to send out another letter, and I think it's important. But Glick does not address all of the issues that this bill raises, and I think that there are many unintended consequences for the language of the bill, so I just want to walk through the committee with them. The Glick decision had to do with a police officer in the Boston Commons, a very public place. And the court said clearly that that citizens have a right to tape record under those circumstances. But it does not define, the Glick decision did not define who is a public official, what is a public place in terms of what's allowed there. It talked about not interfering with a police officer's job, but that interference is, under this bill, would only be physical interference. I think there's some concerns there. So I just want to go through it. First off, this law would fundamentally change our current law on the right to audio tape someone without their consent. As many of you committee members know, we have a law, RSA 570A2, which makes it a crime to audio tape someone without their consent, except under certain circumstances. Now, the Glick decision obviously makes it clear that you can audio tape under certain circumstances a public official. But what this bill does not address is, how does that decision fit with our law that says you can't audio record without someone's consent? If you, as a legislator, were standing out in the hallway and having a discussion with a constituent, the law says you, as a public official, could be tape recorded, but what about that constituent, who is a private citizen? Would the law mean that someone could come up with a recorder and tape record that conversation, even though it was between two people? This law does not make that clear at all, and it doesn't even mention RSA 570A, so there needs to be some recognition of 570A and how it would fit with this law. There is no definition of the term public official. So it's not clear to me. There is a definition in our statutes of public official, which includes any unclassified or non-classified executive branch employee, but shall not include any commissioned, unclassified, or non-classified employee elected by the legislature. That's the only definition in our statutes for public official. I am assuming, based on the testimony of Representative Watrous and other testimony I've heard on similar bills, that that's not, the intent is not to get to that limited group of people. So that creates a problem. There needs to be a definition. One of the other things that I'm concerned about is that the bill talks about not, you can videotape or audio, excuse me, if I keep saying videotape, I mean audio tape. You cannot audio tape. You can audio tape someone so long as it doesn't interfere with the public official's performance of his or her duties. One of the concerns is that physical interference would normally be interpreted as some sort of physical force or something, or getting in someone's way. But one of the problems that we've seen is that audio taping and videotaping has become a way to intimidate public officials as well, and make it uncomfortable for public officials to perform their duties. I just read a Superior Court order about a situation in Keene where some people are video and audio taping parking enforcement officers within 2 feet of the person, and constantly videotaping and engaging the person in conversation at the same time. which is making it extremely difficult for that officer to perform his or her duties. That's not physical interference in the normal understanding of the word, but it is a problem. It's also very intimidating, and I want to pose that to you as, you know, there are people in positions like myself, legislators, people who are in decision-making positions, know that they're going to be they're going to be tape recorded, they're going to be video recorded. We sort of buy that when we take on these positions. But not everyone in public service does that. If you are the person that's at the motor vehicle department counter taking registrations or taking in licenses, do you buy as part of that job that you are going to be audio taped and videotaped all the time? Yes. People do have a right to privacy to some extent. Do you want to have people standing in, for instance, the Department of Motor Vehicles and just audio taping all of the interactions between the DMV clerk and every citizen that comes up? Is that something that is appropriate? Do the citizens have a right of privacy? And could that be interfering with the clerk's performance of their duties? So those are all some of the concerns that I have with this bill, we have with this bill. We recognize that government needs to be open and transparent, and I understand that. I think that there are people who certainly take on the knowledge about being audio taped as part of their public position. One other thing which I did not mention is this bill requires that the device be visible to alert someone that they're being audio taped. As many people know, there are all sorts of devices now that audio tape. It is not clearly just a camera or a tape recorder. So I think it needs to be clear that this device, I mean, we have audio taping devices that are in the shape of a pen. That pen is very visible, but the person who's being tape recorded may not know that that's what's going on. So there needs to be some recognition, not only that it's visible, but that it is a recording device and is being used. I have a copy, and I'm sorry I don't have copies for the whole committee, but I have a copy of a letter that was written by about 20 commissioners in opposition to House Bill 145, which is the bill on which this was tailored. I'd like to offer that letter to the committee just because it raises the same kinds of concerns, and as I said, it was signed by a number of the different commissioners in the state, because it's of sufficient concern. I'm happy to take any questions.
Representative Barron,
Thank you, Madam Chair. Of course, you have a right to your opinion, and you have a right to anything you want as somebody we pay to work for us. We also make the laws, though, and I want to tell you that I plan not only to vote for this, but to strenuously fight for it should there be opposition. But at the same time, I do want to take your concerns into account. You've expressed a few of them. As has often happened in the past, I think you ought to have the opportunity to make recommendations on the assumption that something is going to pass. If something were to pass, I'd like to hear your input as to how you'd like it to be constructively changed before we pass it. We've done this often with other bills. We did it with the Department of Corrections regarding the good time bill last year, so I would like to offer you that opportunity. Would you like to avail yourself of that opportunity to make amendments to this bill?
I'm sure that I would like to take that opportunity, and I'm sure some of the commissioners who signed this bill would like to. If this goes to a subcommittee or something, absolutely. I'm not saying that we are opposing this bill. Absolutely. I think what I said was we oppose it as written because of the problems.
Well, that's what I'd like to offer you. And I did have one other question. You mentioned the Conniff Glick case. Would you like to comment on what happened to Jay Hamill?
I don't know about that specific case. I don't know why that arrest was made. As I said, I did send out under the Attorney General's name a notice to all police departments in the state alerting them to the fact that the Glick decision had come down. I'm happy to provide the committee with a copy of that.
I'd be more interested in Jay Hamill.
I don't
think any citizen should have to endure what he endured.
and Representative Robinson.
Thank you, Madam Chairman. I'd just like to point out, as far as I know, and I'm from Keene, the objection has nothing about being filmed or audio taped. The objection is standing in the way screaming and yelling, following them home from work, going in when they're having lunch and harassing them and screaming and the rest of it. I think if all they were doing was taping and audio and video, nobody would care in Keene, including the people who quit the job because they were tired of being harassed.
Well, I believe that one of the people actually testified, and this is what was in the court order, that even just the constant audio and videotaping in such close proximity was very intimidating. So,
Okay,
I owe that.
I expect to be audio and videotape, and so should they be.
Representative Cushing.
Could you provide us with a copy of the letter that you sent to the local law enforcement in the aftermath of the Glick decision?
Sure, I don't have it now, but I'll find it and send it out to you.
In your reading of the Glick decision and your reading of our current statute, do you see anything in our current statute that's in conflict with the Glick decision?
Well, our current statute says that it's unlawful to audio tape someone when there is a reasonable expectation that you won't be audio taped. And there is a debate right now about what if, before Glick, let me say that, before Glick, there was a debate about whether a police officer in the public had a reasonable expectation of not being audio taped in the performance of his or her duties. I think that the Glick decision provides some context to our law now that wasn't there before. So I don't think that they contradict one another. I think the Glick decision provided an interpretation of the law.
So can you see a situation where a police officer standing, I don't know, say directing traffic on Route 1A at Hampton Beach and barking out orders would have an expectation that he couldn't be audio taped doing that?
If someone's just out there directing traffic and not talking to anyone, I don't see that there would be any reasonable expectation. It was more the, if they're engaged in a conversation with someone. I'm not sure I'm following your
Well, I'm following. I'm trying to find something analogous to the Boston Common. I mean, my presumption is that before the Glick decision, there was an expectation that in Boston you didn't, if you were standing on the Common or any place else, that a law enforcement officer could object to being audio taped or videotaped. That I haven't read the decision, but that's just what the gist I have. I guess I'm trying to figure out, does someone that is a police officer in White Park in Concord or in Beach State Park or any place engaging in a conversation with a member of the public in the course of his or her official duties, do they have an expectation that they will not be audio taped or videotaped?
Well, I think that there are two
Under the
different
law.
things there. Under the law, videotaping, no, I don't think there's any reasonable expectation. You're going to be videotaped. Audio tape, if a police officer engaged in someone trying to have a conversation with someone and they're doing an interview or something, a witness, should someone be in there audio taping that? I think that may interfere with the law enforcement officer's performance of duties, depending on what's being done. So it's not a clear-cut line, and that's why I'm concerned about the physical interference, because I don't think it's just physical interference. Does that help at all?
No, I'm just, well, I can't even distinguish between audio tape and video.
I'm obviously having trouble.
Well, I'm just saying, because audio tape can do something, can videotape, but you can't do sound, video means you can't have any sound associated with
Right,
it.
right.
But if you can read lips or something like that, that's
No,
just parsing of our statute, that's all. I'm not trying to be.
Let me give you an example of something, and this came up several times. There was, at one point, Dunkin' Donuts had videotape and audio tape of their customers. And there was a warning sign that said you're being taped. But the videotape is fine, the audio tape was not. Because that's getting into more private conversations. Anyone can see you being at Dunkin' Donuts, but they may not necessarily be able to hear you. So that's what the difference is. And that made it clear, right?
Yeah, thank you, Madam Chair. Attorney Rice, I would just like to figure out something. I remember while back, we had a bill, maybe it was 145 or whatever. But it was also about traffic stops and people with a police officer, when you're at either a traffic stop or an accident. We had a big thing about that in the committee, that they were being taped, or audio tape, whatever, video, audio, when they were at the scene and it impeded their work. How would this bill affect anything like that? How do
Well,
you-
that is exactly one of my concerns, is if someone is videotaping and audio taping from a distance where people can continue to do their work and not be, and not in the way, that's different than if someone is right up in your face or within a foot with a camera or a microphone or whatever. If people are trying to do a job and someone is interfering by trying to get an audio tape, listen to the conversations that are going on, it makes it difficult to be able to continue what you're doing. So that's interference with job performance. Does that make it clear?
I believe you answered it, and I think if I hear you right, that you're saying this bill may affect that type of stuff, that would change it, this bill.
Well, yes, it basically what it says is, as long as you're not there pushing or physically impeding someone, you can't, it's still legal. And I'm saying that physical interference is not enough protection, because there are times when you can do that without physically impeding someone and still making it difficult.
Thank you.
Any other questions? Seeing none, thank you.
If I could just approach you and give you this copy of this letter.
David, I don't want to mispronounce your name, David.
It's Hiltz, Madam Chair.
No, this is